So kitu ya kwanza ni kuwakaribisha in this meeting. Topic ni law of evidence discussion. Tunataka kudiscuss to generally case laws, what do you mean by different terms. Na the process unapata it is for students, sawa. So we will start by the hardest concepts zenye watu wanafind, na tunataka kwanza na res gestri, then tukitoka hapo tunaingia case laws zenye associated niyo, alafu Ringera pia atatupeleka through Abulfadhi case, a landmark case in Kenya, then other questions zenye pia watu wanapata difficulty kujibu when it comes to a problem analysis question. So Victor pia will also be a co-moderator in some way. So let us start. So Albert Charo, start us with the exceptions of res gestri. Then I'll tell you what res gestri means. And then we'll look at the case laws. So Albert Charo, take the floor. Yeah.
Exceptions to res gestri ama to hearsay?
Oh, sorry, to hearsay. Hearsay ndio tujue res gestri is part of an exception to hearsay, then niingie ndani niseme what is res gestri, and then we flow from there. Thank you for the correction.
Okay, thank you. So exceptions to hearsay. Number 1, we have admissions. Number 2, confessions. We discussed what an admission and a confession is. Number 3, we have a dying declaration. Number 4, we have res gestri itself. Number 5, we have statements made against the interest of a maker. Number 6, we have statements relating to the existence of relationships by blood, marriage. The statement should have been made before the question in issue is made. Hiyo pia misielewa, mtatusaidia hapo. Number 7, we have an opinion as to public right or custom. Alafu ya mwisho tuko na statements made by a person who cannot be called as a witness as provided under section 33 of the Evidence Act.
Asante Charo. So on those, Victor Kapkoro has something to say. Victor, take the stand.
Thank you. Just want to clarify something based on the Evidence Act. And I wish to inform you that you will start from section 34 all the way to section 29. You're going to have around 6 common law exceptions on hearsay. And Charo, one of them we have the evidence on given in formal proceedings, that is in section 34. We have conversions. Look at section 25A1 and 2. Then we have statements forming part of Frankenstein. Public statements. And in public statements, I classified them into 5 parts. Remember, you have the entries made in books of accounts, section 37, entries made in public records, official registers, entries made in charts, claims and maps, section 39, entries in Kenya Gazette, law reports and notices purported to be printed by the government printers, section 40. And number 5, we move to work of references, section 60. Then statement as feels deceased, that is from section 33 of the Evidence Act. So that will include what you said on the dying declarations. Statement made against the interest of the maker, statement made in order to course of the duty, statement as been executed for any public right. So we classify them that way. It will be much easier for us to understand.
Thank you, Victor. Are you done?
Yes, I'm done. And I can show you done that.
Wow. What a great start there. Thank you, Sana Victor. So that's now the process how we run this thing. Now, after the exceptions, let us now jump to the definition of res gestrae. And I want now to share my screen. Give me like only 1 minute, my entire screen. I want to share the notes so that you can follow along on what we are discussing on. So I hope, can everyone see on the screen? Is it visible? Is the screen visible? Anyone just unmute and read the section 33 of Evidence Act? Yeah? So let us look at the messages. So it has been posted. Let me read for you. Victor Kapkuris Moi says that a statement by deceased person, etc., when statements written or oral or electronically recorded of admissible facts made by a person who is dead or who cannot be found or who has been incapable of giving evidence or whose attendance cannot be procured or whose attendance cannot be procured, that's a repetition, without an amount of delay or expense which in the circumstances of the case appears to the court unreasonable, are themselves admissible in the following cases: A, relating to the cause of death; B, when made in the course of business, and when the statement was made by such person in the ordinary course of business, and in particular when it consists of an entry or memorandum made by him in books or records kept in the ordinary course of business or in the discharge of professional duty, or of an acknowledgement written or signed by him of the receipt of money, goods. So remember that also any statement made against the interest of a maker, when the statement is against the pecuniary or proprietary interest of person making it, or when, if true, it will expose him or will have exposed him to a criminal prosecution or to a suit for damages. Why are we reading this section 33 of Evidence Act? We are reading it because it has shown on how res gestrae is applicable now to our Kenyan jurisdiction. Remember, res gestrae is a foreign doctrine. So section 33, as in a layman's language, it has opened a door where even a statement made by a person who's just about to die, let's say you are the one who has cut his throat, and we are going to see the landmark cases on this area. If you are the person who has cut his throat, the last one, and then this person makes a statement to another person, that will be admissible before the court. Remember, the courts are avoiding a lacuna where you cannot extract a dead person for him to give his own evidence. So it has opened that door. So that's section 33 of Evidence Act. So anyone with anything to add or say before I jump into the case laws, then we proceed with the discussion. Feel free to raise your hand or unmute. Okay, Albert Charo, I see you have raised your hand. Take the stand.
Yes, I have a question. And now, like, to understand this literature, can you give us a scenario where res gestrae can be established so that we can understand better?
Okay, for the examples, it is better to give examples with the case law. Now that you are likely, you are insinuating now we jump into the next section on case laws on res gestrae. Is anyone okay? That was just the definition of res gestrae and how it's applicable in Kenya. Then now let us go to the cases for us to understand deeper. So, okay. Let us start with the case of R versus Bedingfield, a case that occurred in 1879. So in this case, a girl was living with her boyfriend until the relationship turned sour. The boyfriend allegedly cut her throat. she managed to run out even with a cut throat and managed to say, in quotes, "See what Harry Bedingfield has done to me." In court, the question arose as to whether this statement could be admitted in evidence, and Lord Justice Cockburn was emphatic that it could not be admitted that time. He said that it was not part of the transaction and that it was said after the transaction was all over. The transaction being the cutting of the throat. The judge held that it was not admissible as part of the registry since it was something stated by her after it was all over. The girl said after it was all over. But remember now, that formed a harsh decision, and under now section 33, that's why I told you to read that section before we start this case. This would have been admitted under section 33 now of Evidence Act, because it says in brief, statements written or oral of admissible facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence will now be admissible. In this case, the girl's evidence will be admissible. Now, that is the first scenario, and that's the landmark case that the teacher wanted us to understand. Is there any other case? What is the Creighton versus R case? Who has that fact? What other cases exist concerning registry? So, any questions so far before I read now the next case that talks on registry application? Any question? No question? Aya, sawa. Let me proceed with the next case law. Let me look. I've had a notification. So Victor Kapkoris, take the stand.
Just want to answer this question. What's the applicability of the country? Kenyan law.
Thank you, Victor. So remember, our jurisdiction still is bound by the common law. So in this application of registry, I believe it has opened a door where not all hearsays are admissible, but we can allow some gap. We can allow when someone is going to die for him or her to be heard in court and justice be delivered. I believe the application of it to our law is now that flexibility when it comes to hearsay. It's an special exception when it comes to hearsay. I believe I may not have answered the correct question, but if you have the answer, you can proceed. And maybe section 17 of Evidence Act, if someone has Evidence Act, can someone project section 17 of Evidence Act, if I'm not wrong, on the relevance of this registry? So in the meantime, Victor, do you have any response to that question?
But before that, I just want to
Yeah, continue.
So what I was saying, we have this case of R versus Kuji. It became under. Therefore, the accused had stabbed their brother, the deceased, and apparently the friend is the deceased. Immediately afterwards, we will see if they go down and made the shopping standing over the deceased of the dagger. It was said that the two circumstances pointers connected, that the wounding or stabbing of the deceased brother must be regarded as part of this doctrine in the trial of the accused, the murder of the deceased. And if you look at that case, it's also explained the same doctrine we are looking at.
Oh, thank you, Victor. And you can allow me also to recap on that case, R versus Kumji, because I had encountered it also in my preparation. So R versus Premji Kurji, it was a 1940 case, if I'm not wrong. And in this case, the accused was charged of murder. That's not in dispute. The deceased had been killed with a dagger, as Victor was saying, and there was evidence that the accused had been found standing over the deceased body with a dagger dripping with blood. That also Victor had talked on. Now the prosecution adduced evidence that a few minutes before, the accused had been seen assaulting the deceased brother with a dagger, and he had uttered words to the effect that these were the words now that are making this case relevant to this trial. He said that, I have finished with you, I'm now going to deal with your brother. Now the question before the court was whether this statement would be admissible as part of the same transaction of murder. Now the holding of the case, as Victor has opined, it was held that they were part of the same transaction because when two acts of an accused person are so interwoven, so linked together as to form part of the same transaction, it is not proper to shut out evidence of one of the acts, even though it may involve introducing evidence of the commission of another offense. I believe that part has been captured very well with the assistance of Victor Kapkoris. So any question, any suggestion, you can also. So I've heard there is a message. What Albert Charo is asking, what about the rules that must be complied with for a registrar to be admissible? I remember Mwalimu talking of things like contemporaries, spontaneous, and such things. Kindly explain. So remember, the questions are also open to all members. By contemporaneous, spontaneous, I according to my understanding, is that the same transaction could have been at the stated time, space. Remember the definition of res gestae. It is a fact or opinion that occurred at that time, at that space. So you cannot, an event cannot occur today, then you claim res gestae tomorrow. It must be that spontaneous. The act happening, the time is now, and the space is here. So I believe, according to my understanding, I have tackled. And Naslata Mwalimu is also asking, aren't these the points to exception of hearsay? So Mwalimu, if you can rewind back to where we started, you listen to the exceptions of hearsay when they were being read one by one. So I believe you will be able to rewind the video after this. So now, anyone with anything before I jump to another landmark case, R versus Ratten. Remember, it's a landmark case that we cannot avoid. Let me look at the notification. Victor Kapkoris, take the stand.
Just one question. The statement made by the observers concerning the performance of an act concerning the makers of the statement, their minds or emotions, and the physical sensation. That's the statement made by the observers.
Oh, Victor, if I can get you clearly, you are asking whether even a third party can be included in this doctrine. So according to what I've read, the case laws on res gestae, I believe the answer is yes, because it leaves a room for a stranger also to encounter a certain act in action, and then his evidence will be admissible before the courts, because maybe that person that the act was being done against maybe is dead at the moment. So I believe it also involves third parties at that instance. Anyone else can can try to suggest what he understand or she on that question posed by Victor. Victor, so any other additional, is your question answered, Ama? So I believe I've seen a message from Victor. It says that generally statements made by participants in an event are admissible in evidence since they were present when the event took place. An exception will arise in cases where the statement was made after the event was concluded, yet it is to be relied on as evidence. I believe now that has answered the question, and the case to support this comment is from R versus Bedingfield, a case that occurred in 1879. So you can take that chance and be reading through that case. So are we okay now if we proceed to the Ratten versus R case? Now let us jump to the R versus Ratten case, if everyone is okay now. So if I can remember, R versus Ratten case occurred in 1972, and in that case, Ratten was charged with the murder of his wife. He offered the defense of accident. He just said that was an accident. He said that while he was cleaning his gun and he accidentally went off injuring his spouse. There was nobody else at the scene of crime or at the point where the incident occurred, and the prosecution sought to tender evidence of a girl who worked with the telephone exchange, who said that a call had been made from the accused house at about the time of the murder. The girl said that the voice on the phone betrayed the emotion of the accused. She was begging to have the police called over, and before the operator could link the woman with the police, the phone hung up on the woman's side. The question was before the court now, was the statement by the telephone operator admissible as part of the transaction? Did it happen contemporaneously, as Albert was asking, with the facts in issue? The court held that the evidence of the telephone operator was admissible, and in explaining why, the Privy Council explained that the important thing was not whether the words were part of the transaction, but whether the words were uttered during the drama. The court also said that the particular evidence of the operator contradicted the evidence, which was to the effect that the only telephone call outside from his house during the murder was a call for an ambulance. At that point, if I may be clear, the person who had killed this wife had also made another phone call, but his evidence was in contradiction because he says that the only call that came out from that home was a call of an ambulance. But remember, this girl had telephoned an exchanger who worked with the police department, and she was trying to link up with the police sector. Now, how will this sentence implicate Ratten? And now the court held, if the evidence is admissible, Ratten is guilty for murder. So I believe, is the case law clear? And that part of the res gestra in that case. So also jumping to the comment section, I see Victor Kapkoroi says that Section 6 of the Evidence Act provides that facts which are the occasion, cause or effect, immediate or otherwise of relevant facts or facts in issue, or which constitute the state of things under which they happened, or which offered an opportunity for the occurrence on transaction, are relevant. Let me allow Victor to explain that comment that he has said. Victor, take the stand.
Correction.
Yeah.
Not section 6. I'm giving you the correct section. Sure.
Okay, thank you. So scratch that section 6. But what he's saying, that the comment he has extracted from the case of Markin versus Attorney General of New South Wales as the correct section is being searched. And also in the comment, he has gone ahead to say that these statements are admissible and must be statements made explaining the fact which is in issue or is a relevant fact. Remember, those statements should make sense before the court. They must be so related. So I believe at that point, anyone else with a comment or anything to add on, you can say, because I see Victor Kapkores has corrected the section and says that Evidence Act provides as follows: any fact is relevant which shows or constitute a motive or preparedness for any fact in issue or relevant fact. He has tried to explain the meaning of the statement must make sense before the court. So I believe at that point everything is still clear and running, unless anyone has a comment or a question. The floor is open. Now I believe we have tackled the landmark cases. If anyone else has any other case or a contribution, feel free, because we want to jump into another area that the exams also look at when it comes to law of evidence. So allow me to take this chance and invite Ringera if he's ready. Ringera, are you ready? So Ringera, I want to invite Ringera to take us through a case brief on a landmark case in Kenya that distinguished between a confession and admission. So I want Ringera to be so clear in this case, to take that time so that all persons will understand this case to a layman's definition. We want also to hear the 6 statements that the judges said that directly distinguish between admission and a confession. Ringera, if you are ready, just unmute and now take the floor.
Good evening.
Good evening.
The facts of the RV Ahmad Abolfadi case. So there are 2 Iranian nationals, that is Abolfadi and another one, who visited Kenya and they went to Mombasa. They were said to visit a certain golf club by the name, it is on Mamangina Drive. It is in Mombasa County, Mamangina Drive. That is the Mombasa Golf Course. And they visited the place at least 3 times. This is as per the witnesses, that is the taxi driver to get to the golf club. And then the treasurer of the golf club and 1 member of the golf club. So these were the key witnesses who give information on the Iranian nationals being seen at the scene of where the RDX explosives were found. Now, when these Iranian nationals were almost exiting Kenya through the Jomo Kenyatta International Airport, they were arrested by that terrorist police, and they were taken there to the Mombasa Golf Club, where Abul Fadi admitted to the police that he knew where the RDX explosive was hidden. So I will not go through the issues, or just go direct to the difference between an admission and a confession as put out in this case. And I will only explain the Supreme Court part of it. So Section 17 of the Evidence Act defines an admission as a statement or oral documentary which suggests any inference as to a fact in issue or relevant fact, and which is made by any of the persons in the circumstances here in automation. Those circumstances are mentioned thereafter in Section 17. And then in Section 25, which defines a confession. As a confession comprises words of conduct or a combination of words and conduct from which, whether taken alone or in conjunction with other facts proved, an inference may be reasonably true that the person making it has committed an offense. So, then there's a acid test that was found out in the case Ram versus State. It is an Indian case. It is persuasive in the Kenyan jurisdiction. The acid test distinguishes between a confession and an admission is that the confession can be based on a statement alone. It is a confession, and where some supplementary evidence is needed to authorize a conviction is an admission. So for you to you say that a certain statement in a confession, it has to lead to absolute conviction. And we also applied in class the requirements that must be met for any statement to be admitted as a confession as per section 25A(1), the Evidence Act. Those are that it should be made before a judge or magistrate or a police officer other than the investigating officer, not below the rank of Inspector of Police, Chief Inspector of Police. Sorry. Now, after we have outlined that a confession absolutely leads to a conviction, and an admission, there must be some supplementary evidence for it to be admitted in court, or for it to lead to conviction. Sorry. And in this case, it was outlined that the fact that Al-Fadi admitted to the police that he knew where the explosive was hidden, it became an admission because the police needed also to corroborate the information by the taxi driver, the treasurer of the golf club, now plus the admission that he knew where the RDX was for the conviction to be found. The Supreme Court summarized 6 distinctions between an admission and a confession. A confession, so I will read word for word. A confession untainted by any legal disqualification may be accepted as conclusive in itself if the matters confessed. So if it goes as per the requirements in section 25, then it is accepted as conclusive to lead to a conviction. An admission, however, pursuant to section 24 of the Evidence Act, is not conclusive proof the matters admitted, which may operate as an estoppel. So an admission is not conclusive proof, but it operates as an estoppel. And I did not find the correct meaning of the statement that it's not conclusive proof of the matters admitted, but it may operate as an estoppel. So I will also find out that at the end of this discussion, a confession is a direct admission of guilt, where an admission amounts to inference about the liability of the person making the admission in the cause. So a confession is a direct admission. So if you asked, how do you plead? You say, I am the one who was found with this and that, then it leads to a guilt and you are convicted. However, the admission now leads to an inference that the person making it, because when a party said that he knew where the RTX was hidden, it is in real circumstances that any other person would have known where the explosives were. So if a party says he knew where they were, it is just an inference that he has liability for placing the RDX in the gold club. The confession always goes against the person making it, and a confession can only be made by the person who is the accused. So it only goes against that person, and is the only person who can make it. An admission may be sometimes proved by or on behalf of the person making the admission, as stated in section 21 of the Evidence Act. Now, outline 4. Confessions are made in criminal cases, while admissions are made both in criminal and civil cases, because it's only in criminal cases that you asked how do you plead. So if you plead guilty, then that's a confession, and it's only made in criminal cases. Admissions are both made in criminal and civil cases. Confessions must be voluntary, but admissions need not be voluntary. The reason for this is the confessions, they must come from the person making it, because if we were to admit any confession, then there would be torture and maiming of the person who is being interrogated by the police. So this person has to take the initiative to provide this information to the police. For admission, you find that the Constitution, where it provides the rights of arrested persons, that they need to be informed of the reason of their arrest, and that their silence is important, because if anything they say can be used in the court. So this admission, maybe when somebody is arrested, he starts blabbering stuff. So if he blabbers any stuff that is useful to the police, then it's just taken as an admission. And the last one is confessions cannot be made by the accused. Admissions can be made by any person. So if you were to outline these 6 distinctions, then I think you would have covered the distinction between a confession and an admission. Thank you.
Wow. Wow, Ringera, that's a good analysis of the case there, landmark case in Kenya. I'm finding it a challenge to add someone in the meeting room. Who is it? So in the meantime, as I try to add her, Naslata, someone can be saying something as I will come to address the questions. So there is a question in the comment section that asks on what is the Kenyan position. This question has been asked by Victor. What is the Kenyan position on the admissibility confessions? Are there any inhibiting factors to such cases? What will happen if an accused fails to invite the third party? Should the third party be a close blood relative? And is there any provision on that? Also comment on Section 61 in relation to Section 25A of the Evidence Act. So allow me to tackle the question as I also look on how I'll add Naslata. Someone please share the invitation link to Naslata using WhatsApp, because at the moment I'm projecting my screen and some messages are confidential, so someone take that initiative. So let me answer the questions that have been addressed. So let me jump into the answers. So introduction to the requirements of that question, because let us analyze on the legal perspectives that outline on confessions in Kenya. And one cannot start with any other authority in Kenya without mentioning the Constitution 2010. What are these articles? Let us start with Article 49 of the Constitution. And it has guaranteed an arrested person, among others, the right to be informed promptly in a language that the person understands of the reason of the arrest, the right to remain silent, and the consequences of not remaining silent. The right to communicate with an advocate and other persons whose assistance is necessary, and the right of not being compelled to make any confession or admission that may be used in evidence against him or her. Also, Article 49(4) of the Constitution provides further that evidence obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be excluded if the admission of that evidence will render the trial unfair or will otherwise be detrimental to the administration of justice. And finally, also in the Constitution, Article 52(1) of the Constitution says that it has guaranteed an accused person a right to refuse to give self-incriminating evidence. Now, if we jump into the Evidence Act, also, there are some sections that are very vital when it comes to a confession. If we look at Section 25, as also Victor has seen in his question, the difference between Section 61 and 25A, let us read Section 25. A confession or any admission of a fact tending to the proof of guilt made by an accused person is not admissible and shall not be proved as against such person unless it is made in court before a judge, a magistrate, or before a police officer, other than the investigating officer, being an officer not below the rank of Chief Inspector of Police and a third party of the person's choice. Before I continue with this section, I want to raise the point that was earlier in discussion in class on this person known as Chief Inspector of Police. Is the rank supposed to be below or above? Victor, I believe you can take us on the definition of who is a Chief Inspector of Police.
In National Police Service, we have 14 ranks. First rank being the constable, second rank being the corporal, third rank being the sergeant, then you move to senior sergeant, fourth rank, then inspector, fifth rank, sixth rank is chief inspector. Then we have assistant superintendent of the police. We have superintendent of the police. We have senior superintendent. Then we have the commissioner of the police. We also have assistant inspector general of the police. Then we have senior assistant, deputy inspector general of the police, and inspector general of the police. So for this case, Section 25A Section 25A says that being the rank not below. Not below means not less than. And that means the person who is supposed to take the confessions must be chief inspector, assistant superintendent of the police, SP, SSP and above, and not the inspector. So the first 5 ranks are included in 25A1.
Wow. That's a good explanation there from Victor Kapkoros Moi. So, if I may, before I conclude, I am seeing somebody raising his hand. Oh, Jay, take the stand. Oh, Jay was clapping. Oh, sorry. So let us continue. So, there are also some questions that we have heard from Victor that we were talking on Section 25A of the Evidence Act, and he has gone ahead to define the ranks to an extent that now we are confident on who's a chief inspector of police. And when it comes to a third party, allow me to address that also before I make my conclusions. Now I want to address an important area, because at times a person may make a confession before an ordinary citizen, a private individual. What is that? Will the admission or confession be admissible? And Ringera also said on the difference between confession and admission. Admission requires a step further before the conviction is granted, but a confession is a direct conviction. Now, let us look at what we call extrajudicial confession. An extrajudicial confession has been defined to mean a free and voluntary confession of guilt by a person accused of a crime in the course of conversation with persons other than the judge or magistrate seized of the charge against himself. They are generally made before private individuals. These are the ordinary citizens. Extrajudicial confessions can be made to any person or body of persons, and it is not necessary that it should be directed to a particular individual. It can also be made in the form of a prayer. It can also be made to a judicial magistrate in his private capacity, or any magistrate who is not empowered to record confessions. Remember, this is a new area, and we want to test whether that area applies to Kenya. And there is a case, Republic versus Nicholas Ngugi Bagwa of 2015, where Justice Lesit says that, in my view, there are other confessions which are also extrajudicial confessions, if made to any person other than a person in a position of authority and in the ordinary day life. Such confessions will be admissible under Section 26 of the Evidence Act if made voluntary without any inducement or force of any kind. Remember, we were discussing on the legal perspective that discuss on confession and admissions in Kenya, and we have discussed Constitution and the Evidence Act. We have said Section 25A. Allow me now to mention Section 26 before now I proceed on how extrajudicial confession will be admitted, what is the threshold, and in the process we will also answer the question that also Victor had raised on whether a third party is a must, and what if the accused says, I don't want a third party. What will the court say? Now let us go to Section 26, then we proceed to extrajudicial confessions. And Section 26 of the Evidence Act, as Justice Lesit had opined, provides that a confession or any admission of a fact tending to the proof of guilt made by an accused person is not admissible in a criminal proceeding if the making of the confession or admission appears to the court to have been caused by any inducement, threat, or promise having reference to the charge against the accused person, proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds which will appear to him reasonable for supposing that by making it, he will gain any advantage or avoid any evil of a temporal nature in reference to the proceedings against him. Now that is Section 26 of Evidence Act. Remember, Section 26 of the Evidence Act is also in line with the evidence out of court confessions rules of 2009 that were published on 27th March of 2009. The rules set out rigorous procedure that must be followed before confession is recorded from a suspect in Kenya. And now Section 25 of the Evidence Act and the rules made now are as a result of concern expressed by citizens of Kenya in regard to the manner in which torture was being used to secure confessions from suspects. So those rules were there to guide, to protect the citizens. Now, let us continue to what we were discussing on extrajudicial confession. What is the threshold? Because that's the most important thing in this matter. The threshold principle of an extrajudicial confession was captured in the case of Rajasthan versus Rajaram 203. I repeat, Rajasthan versus Rajaram of 203. It's not a binding case, of course, in Kenya, but of persuasive nature, but it has set a threshold that has been applied all over courts in the world. And the court stated that such statements, when we were, let me address now the raised hand before I continue on the threshold of an extrajudicial confession. J. Kim, please proceed. Unmute, please.
My question would be about the section 61. Section 61 that differs as compared with section 25. So, what would be the implication of that?
Thank you, Ringera. I believe you are. Continue.
And also the extrajudicial confessions. So, how are these given?
Thank you, Ringera. Your question has been tabled, and now let me go to the threshold, because it will also answer the question that on how extrajudicial confessions made to a private individual will be administered before the courts. Remember, I was saying the case of Rajasthan versus Rajaram in 203, it laid down the threshold. And number one, it says that it should be made voluntary and should be truthful. Number two, it should inspire confidence before the court. And number three, an extrajudicial confession attains greater credibility and evidentiary value if it is supported by a chain of cogent circumstances and is further corroborated by other prosecution evidence. So that means in itself, it's not yet of credible value. And number four, for an extrajudicial confession to be the basis of a conviction, it should not suffer from any material discrepancies and inherent improbabilities. Such statement, the last threshold, such statement essentially has to be proved like any other fact and in accordance with the law. I believe that has set the threshold before an extrajudicial confession is administered before the courts of Kenya. Remember where this extrajudicial confession arose from? We were talking on the legal regime that has outlined on confessions in Kenya, and we had already said on Constitution 2010, the Evidence Act, and now we want to talk on evidence on into bracket out of court confessions, rules of 209. And to be specific, let us look at rule number 4. And the rule number 4 has given mandate on the recording officer some specific observations that must be recorded before the ordinary confession has been stipulated and signed by the accused. And A says that the recording officer shall ask and record the accused person preferred language of communication. 2, shall provide the accused person with an interpreter free of charge where he does not speak Kiswahili or English. 3, the recording officer, sorry, let me handle an invitee here. Oh yes, let me admit all. Okay, all is set now. Thank you for joining the platform. So as you are continuing on, I see Ringera has raised his hand. So Ringera, can you proceed?
Would you also share the PDFs or the information that you're referring to, so that maybe people can refer to it later.
Oh, thank you, Ringera. Remember, my screen on sharing, it has brought issues. Now that's why I'll give you the link. It's in the website, thekenyalawreports.com. Let me provide the link in the comment section directly. That will take you to what I'm reading. Just in a moment, so that everyone will read through what I'm saying. So check the comment section. I've pasted the link there. So that's the information, and that's where I'm reading the information from. Thank you for your concern, Ringera. So if I may continue, now everyone has the link to the information. I was saying let me get back to where I was. So I was on rule number 4 of the Evidence Out of Court Professions Rule of 209, and I was on a point where the recording officer will ensure that the accused person is not subjected to any form of coercion, duress, threat, torture, or any other form of cruel, inhuman, or degrading treatment or punishment. Remember also in that link, you will also find cases where the accused claimed torture, and in that way they escaped from being imprisoned because the confessions had been obtained out of torture. And also we'll also look at a case where the prosecution followed all the rules correctly and they granted justice to the victim who had brought the matter. So if we also continue, still under Rule 4, says that the recording officer shall ensure that the accused person is informed of his right to have legal representation of his own choice among others. And lastly, the recording officer shall ask the accused person to nominate a third party to be present during the confession, and the particulars of the third party and the relationship to the accused must also be recorded. Now that brings me to the question that Victor Kapkoris had raised on the issue on third parties. And what if now the accused party does not want a third party? Remember, the link also contains a subtopic that I don't want a third party present officer. That part will answer the question on will the confession still be administered if the confession was obtained between the recording officer only and the accused. And the case is Josephat Manoti Omwancha versus Republic, a criminal appeal number 41 of 2019. And what caught my attention in the case was the fact that the appellant had raised 8 grounds of appeal that were condensed into 4 thematic issues. In the appellant's written submission, I was concerned with only one issue because for my relevance to still stick to this topic under confessions and admissions. And it says that whether the impugned confessionary statement, in brackets impugned statement, taken from the appellant was admissible in evidence, and if the answer to the question is in the affirmative, what is the probative value of the same impugned statement? The officer had said, for those who want to understand this case in a flow, that the accused said he did not want either a friend, advocate, or a kin to be present while making the confession. The officer had also said that he had said he did not want anybody to know what he had done, so he did not want anybody to be present while he was making his confession. It is his right to have someone present, but we cannot force him. I was seeing him for the first time, so I don't know his signature or handwriting. The officer was insisting on seeing him the first time so that his signature won't be questioned on forgery. And the court went ahead to say that it is a requisite and an alternative person could have been suggested instead. And if I read the holding verbatim, it is explicit from the record that it was only SSP Grace and the appellant who were present throughout during the time the recording of the impugned confessionary statement took place. Grace never asked him if he wanted any other person of his choice other than a family member to be present. the officer never provided an alternative. And that's what caught the attention of the court, to an extent that the court found that the trial judge had fell into error when she failed to properly appreciate and uphold the above prerequisites when determining the admissibility or otherwise of the impugned confessionary statement. Now that, in conclusion, says that if the accused says that I don't want a relative, I don't want this person to be present, only me and you, officer, don't accept. Provide an alternative of a person that will still be able to sign and approve that the confessions were in alignment with the rules. The court is not concerned with the freedom of you not selecting a third party. I believe at that point, we have looked at extrajudicial confessions to the end, and I will conclude with a case where a case was overruled because the evidence was not corrected in accordance with the rules. And the case is R versus Yasin Sambai Juma, 2019. And the brief facts were that the respondent was facing 2 terrorism-related charges brought against him under the Prevention of Terrorism Act. The applicant pleaded not guilty to the charge. In the course of the trial, the prosecution sought to admit into evidence a confession allegedly recorded from the respondent during his interrogation by the police. The respondent objected to the production of the said evidence on the grounds that the same had been obtained after he had been subjected to torture, coercion, and placed under undue duress. The trial court ordered a trial within a trial to be conducted to determine the admissibility of the said confession. And after conducting the trial within a trial, the trial court ruled the confession inadmissible in evidence. But the prosecution were aggrieved by the decision and they challenged the trial court in the Court of Appeal. And the officer recording the confession says that he had categorically stated that the respondent had made no complaint that he had been tortured. He further stated that the respondent had not requested for a third party to be present during the recording of the alleged confession. This statement from the officer was in contradiction by the video evidence that was said to have been recorded. And other witnesses also summoned by the prosecution confirmed the contradiction part on the officer, and says that indeed the respondent had intimidated to the officer recording the confession that he had been tortured. The respondent had also indicated that he desired his relative to be present as he was recording the confession. Remember, the police still ignored the pleas of this accused person to have his relative present. And now the court was forced to hold that the appeal will be dismissed on grounds of torture and denial to have a third party representation. But also there is a case where the prosecution team complied with all the rules set out of court's rules of 209. And it's important we also acknowledge that the prosecution at times, they also do their job. And Republic versus Nicholas Ngugi Bagwa of 2015, in support of their submission, she submitted that the officer who took the confession complied with the law and in fact electronically recorded the confession. Remember, the person confirming the confession is the accused, and she is saying that indeed the prosecution complied. The DVD was produced into evidence. A certificate of compliance was also provided, since a certificate of compliance is a requirement under section 106A and B of the Evidence Act, and the respondent did not adduce any evidence to rebut the prosecution's case. And that now will form the conclusion part of my presentation. Unless now anyone has a question or an addition, remember this is a discussion on areas likely to be asked. Now I'm asking a direct question: what other area should we expect? And also the question before I forget, section 61. Ringera, you raised that point. Where is the conflict between section 61 and section 25A of the Evidence Act? Please shed the light. Anyone who also can open section 61, you can also have a view on it.
It was a question by Victor on the comment section. So I wanted maybe somebody to explain more on that.
Victor, I believe the question has proved to hit a dead end because we want to understand on what angle is the question coming from. If you can say something over the question, it will be a great chance. Are you ready, Victor?
What I was asking was on the confession one, the one that is guilty of confessions. And the second part was on what are the factors which are likely to make the confession not to be successful. And let me answer this question. In relation to that, if an accused is arrested today and will be escorted to police station, is or she's being threatened, being coerced to admit what he has done. Then the following day, this accused is said to make a confession. Will that confession be admissible?
Oh, I believe now the question is clear. Assume now you are the accused person, you are in this van and the police are surrounding you, and now you decide you have no alternative but rather to make this confession for them now to stop harassing you. Remember that confession has been made out of heat of the moment. You are admitting to something that you are not willing to admit to, and according to me, that will be it will be against the rights of an accused person as provided in the Constitution. One, right to remain silent because they are forcing this person to speak. That's an infringement against the Miranda rights that requires one to remain silent, and anything that they say will be used against him. That's an area where the police are likely to infringe concerning that matter. And also the right not to give self-incriminating evidence is also a key area that the police are infringing on this accused person. Any other person who has something to say? Victor Kapkoros has raised his hand.
I'm also interested in the case of diligence. Admissions by diligence admissible, and confessions by juvenile admissible.
Those questions are really triggering our minds. Admissions or from juveniles, are they admissible before the courts? What's your view on that matter? Anyone who has something to say? Ringera, what can you say over from juveniles, admissions from juveniles? Oh, please open the audio. So sorry as I add someone. Yes, so let me admit someone. Yeah, so thank you. So what's your take concerning juveniles confessions? Do you believe we can take over the matter? Lavin, you look so lively today. What can you say concerning the matter? Are you still following? You are so silent. I mean, you don't want silent misrepresentation. Lavin looks like she's not around. Gloria, I'm seeing you. Anyone? Oh, Gloria's raised her hand. Gloria, continue, please. Let us start with Gloria, then Naslata.
I think that maybe confessions from juveniles are mostly not admissible because they're more believed to give false confessions, not unless the event in question was so traumatic to a point that the juvenile cannot be lying. That's my take.
Wow.
Do you have provision on that?
No, not really.
Okay. Oh, Naslata, I also see you have a point. Please continue.
Me, I wanted to say, like, you kuna square truly in class, they said that the confessions or admissions from children or juveniles ought to be collaborated with some backup, let's say, information. And they'll be the judge or whoever is questioning them atawafuatilia and will like aone kama they understand what they're saying or the consequences of them saying this confession or this whatever evidence that they're giving. I think so.
Wow, thank you. Thank you, Naslata. Thank you, Chemutai Gloria, for your feedbacks. And also, if I can also support the question, the previous speakers, do you know of a concept known as voir dire? In this instance, I believe it's from section 50-something there of Evidence Act, is this that a judge or magistrate will ask this kid on some questions. Does the kid understand the veracity of lying under oath, e.g., for example, on do you attend churches? What is the repercussions of lying under oath? Do you believe in God? Like, these are some leading questions that if the child is not understanding the veracity of lying under oath, does the child also at first instance understand what is an oath? Then in that instance we can say that whatever the child will be saying, if indeed the judge will be satisfied, there is no provision that says that these are the questions where the kids will be asked. It is just in the discretion of the judge. And also the questioning also applies to some older people or some people who are going to suffer from death in soonest. So also some people also suffer from dementia, remember, old people. So a voir dire will confirm that you really understand the veracity of perjury. Perjury, remember, is an offense in Kenya where you'll be jailed for 3 years for lying under oath. So I believe the questioning, and now if the child continues to make this confession before the judge and after the judge has been satisfied that the child is ready, now we go to the next step of corroboration. Corroboration, as Naslata says, is that where they want to back up this confession or evidence from this minor with some further evidence to make his point more concrete. But remember, Sexual Offences Act says that a confession from a minor or evidence from a minor will not require corroboration, and in itself is a corroboration. So I believe in that part, I have also taken part in answering the question. Anyone else with a contribution? Nasi Mwalimu, continue please.
Okay, I wanted to add on your doctrine of voir dire. Now, it's like also those elderly people, those who are suffering from mental illnesses like schizophrenia or those who are on amnesia. Also, the judge is going to ask them questions and apply with children and those elderly people. And the answers don't have to be correct. They have to be in the same context. Like, ukiuliza, which color is this? And ajibu red or black, but the answer is wrong. But the judge anajua, like, this kid knows what he or she is talking about. Unless anauliza which color is this, and then asema it's a car. So hizo ndo circumstances, hizo questions. Now if the child or the elderly person knows what the questions mean and how to answer them, that the judge is able to get from the answers that the child knows what he or she is talking about, then the evidence inaweza kuwa admissible, and as Victor said, nafaa kuwa collaborated with something else. Na hata mimi nilikuwa nataka ku highlight the part of Sexual Offences Act, like their words they take.
Wow, thank you, Naslata. And I also see Victor has raised his hand, but before and also I give him the chance. I remember a certain cross-examination where an elderly was asked, on, do you understand the veracity of lying under oath? And this man was very furious. So I believe in some point, the questions are different when it comes to minors and elderly people. So because elderly people may at times view the question like an infringement to their elderliness. So Victor Kapkoris, now please take the stand.
In relation to the question which I've just asked, I direct you to the case of the public funds. That is, you can't remember the citation. But what I want you to know is that the right of the child ought to be protected more carefully than those of the adult. Because the child will have that resistance, maturity, understanding as that of the adult to cope with any situation when you should be questioned by the police. So in relation to that case, the sitting judge set out 5 principles which ought to be followed when making or recording the confessions of the child. And the first one, the judge says that this child requires to be accompanied by the relative or the parent, and that relative or the parent must be the same gender, the same sex as that of the child who is going to be questioned. And you should accompany the child to the place of interrogation. That's the first principle given by the judge in that case. The second one, he said that the child must be given at the place of interrogation a room. And that room, that relative must be present. He must accompany him, and the choice of deciding whether he wishes his relative to accompany him or not must stay until when the interrogation is over. That one is to carry out the questioning as soon as the child and his relative arrive at the interrogation place. Then the third one asks the child, as soon as the question is given, whether you understand it, and if not, give him an explanation. Then the last one, the judge says that detain the child if there's a possibility of proceedings.
Before you go, Victor, I want you to spell the citations of the case. If now even for the people not to understand.
The case was R, the accused, this is 3 A Q U E S. I can't remember when the year when it was decided. And later I can get back to you before you finish.
Thank you, Victor. That's a very informative discussion there. And the case is a landmark case, I believe. If you search, you will also be ready to find it. I see Naslata is also raising her hand. Naslata, what do you have to say?
Sorry.
Oh, sawa. Anyone else? Lavina, I'm also seeing you have raised your hand. Oh, sorry, it's not a raised hand. So, Lavina, I'm seeing that you are saying that you have a problem with your microphone and you are apologetic. So let us hear from Chemutai Gloria, who has raised her hand. Gloria, take the stand. Unmute, please.
No.
Oh, sawa. So I believe everything is still flowing. Those were admissions and confessions in Kenya. So in the chat box, let me look what's happening in the chat box. Albert Charo is asking, it's a self-assessment questionnaire that everyone will be able to answer. What is a confession? 2, examine the law governing confessions in Kenya. 3, compare between admissions and confessions. 4, what are the rules applicable to recording of an out-of-court confession? 5, explain the disadvantages of relevance of confession as a tool of getting evidence. 6, examine 3 cases upon which court rejected evidence produced through confession that did not comply with the law. That's a good self-assessment questionnaire that Albert Charo wants everyone to keep at the back of their mind. And just as a, by the way, question, do you believe advocates should also learn other areas of advancing science? Like now, when it comes to cyber crimes, the threshold of now obtaining the evidences will also result to advocates learning skills like technology. Sometimes white-collar crimes also involve the signature frauds. And I believe the forensic science is a broad area and has talked on how to determine fake signatures from a document and other areas. So keep that also at the back of your mind. Like at the way the technology is growing, we will be forced to look at other areas of science. Remember, jurimetrics is an area that mixed science and the law. And at that point, I believe everything now is clear, unless there is any additional or area that someone wants to say. Please continue.
Just want to ask this. In the process of trial, you have 3 types of examination. Examination in chief, cross-examination, and re-examination. Do we subject confession to any of that?
At that question, I stand guided, Victor. Who else can try on the question posed by Victor? Victor, I believe no one has read the criminal procedure to that extent. I believe you can shed more light on that question. Victor Kapkoris is also thinking, and I believe we'll also have more discussions like this. The next discussion, as Victor Kapkoris is thinking on another area maybe where people will be left with an assignment. Remember, in every discussion, we must be giving out assignments, and that will also form part of an assignment to you. Go look on what you can say concerning the same. And someone is asking, Naslata is asking on what next unit will entail. And the next discussion will be of contract law. I stand guided if that's, so everyone is in agreement. We'll discuss on contract law, then later deal with partnership law. So under partnership law, we'll also deal with Partnership Act section by section, and we look at the course outline to make sure we are aligning with what the course outline says, together with some landmark cases on partnership law. Now, the schedule of the discussions is as follows. Tomorrow at the same time, 4, we'll start at 4. We'll deal with contract law. We'll look on the vitiating factors, because that's the area we have covered so far, one by one, and the landmark cases, and also the cases where the students were told to talk on. We will also look one by one concerning the same. And then on partnership law, I stand guided. When do you want partnership law to be discussed?
Just communicate later.
Sawa. So let us communicate later concerning partnership law. But tomorrow, as we have said, let us meet on contract law. Everyone still go and do research. When you come with content like today. It was a very engaging discussion point where we understood various areas that people never knew. And closing speech marks, I can give anyone to say a comment or the way forward concerning these kinds of discussions. Anyone?
So I said, but we forget to look at the procedures for recording conversations. So you can take that on and work on that. That was a pleasant evening. Good night.
Looks today like you have a lot of assignments. And remember, the procedure of obtaining confessions in Kenya is an area likely to be tested and should be in your fingertips. Just go over through out of courts evidence rules 209 and do a summary of the same. So up to that point,